Pero kung hindi ako ang nag-correct noon, at sa ko, wait, ito si Sandoval, hindi naman makaling ito eh. Alam mo na, mga professors, kanya-kanya yan. You remember two justices? Pagalingan sila sa authority. Sabi nung isa, those who enrolled in my review class, I'm very glad you enrolled in my review class. Civil law. Because, in civil law, as authority, I am only second to God. Yun ang kanyang pagmamayabang. Natinig nung rival niya. Rival siya. Sabi nung, sunjat, naka-rival niya. Oh, I didn't know that my friend has regarded me as God. Pag sigurado kayo, sasabihin ko naman sa inyo, kung sino ang parang sana, you can. This is the opinion of Justice so-and-so, and I subscribe to it, full credit ka na. Another example of an impossible crime. Any person performing an act which would have been offense against the person so property, were it not for the inherent possibility of employment, or on account of the employment of inadequate or ineffectual means. Example, if Mr. A wanted to kill his common law partner, yung kanyang kalipin partner, binibigyan nila ng lason, tigkukunti lang. But his living partner is working in a mining factory and became immune. Kung konti-konti lang ang lason, he became immune. So, there was no injury. Konti-konti lang. There was no injury internally and externally. You can find him guilty of attempted murder. There was no injury. The crime committed is impossible crime to commit murder by the use of inadequate. Example of ineffectiveness. You wanted to poison your friend kasi inagawan ka ng girlfriend, inagawan ka ng boyfriend. Babae ito, gustong lasunin yung kanyang kaibigan. So, he approached a doctor of veterinary science, and pretending, Doc, papatayin ko kasi yung aso kong matagal ang may sakit, kawawa naman naawa na ko. Hindi ko lang mabaril o matagal. O sabi ng veterinary, okay, I'll give you a powder. You mix this with his food, pataya. Okay. The veterinarian didn't know. Ang lakson pala yung kaibigan. But the veterinarian committed everything. He gave an ordinary powder. Hindi, nagkamali siya. So, the accused, believing ito talaga, mixed it with the food of his friend, offered it to him, to her. Of course, the friend didn't die. That is impossible now. Through ineffectiveness. There is a complication. Suppose the intended victim is allergic to powder. And after eating it, when mixed with his food, she suffered allergic reaction and was hospitalized for 2 weeks. With what crime now? Would you charge the one who gave the ordinary powder? You say physical injuries, 2 weeks, 10 to 13 less serious, but there was intent to kill. Gusto niya patayin eh. Can you consider powder as poison? It could be considered. My answer is, this is attempted murder. Because there was intent to kill. This is not only physical injuries. If that problem is given, this is already attempted. No longer impossible crime. because there was injury. And since there was intent to kill, this attempted murder by Mr. Bush. Sometimes, merong question na lalabas yan. A law student was flanked by a professor. A professor 70 years old. Matanda na. The lady law student didn't feel she should flank because bakit ako pinagsak ng walang yung professor nito? So, she approached the professor, pinagmumura niya. Ano? I got 90, etc., etc. What the professor was explaining to him, lalong nagalit si lady law student, the professor suffered a heart attack. She had a faint attack. She suffered the attack, she died. The prosecutor filed a case of grave oral defamation with homicide. Can you answer? Well, the question is this a correct charge of the prosecutor? It's either way. Under Article 48, when a single act constitutes two or more grave oral state felony, minumura niya, single act, grave oral defamation, last grave felony, homicide, grave felony. It could be complex crime of grave oral defamation with homicide. On the other hand, if somebody would kill a person by stabbing him, he first committed physical injury. When he kills him, physical injury is no longer done. That is homicide or attempted homicide. So, it could be mere homicide. It's how you reason out. Okay. If the act in impossible crime would fall under other provisions of the revised penal code, there is no impossible crime. Do you remember the case when he took fancy on the watch of his classmate? Ang gusto niya watch lang eh. So, he waited for his classmate in one dark alley with a gun, told him, pareha ka na yung relo mo. It so happened that the classmate left his watch. Hindi niya dala eh. Sabi, pare, hindi ko dala. Kung gusto mo, meron akong wallet. Kung gusto mo, maski 5 relo, pwede mo bilhin sa dalaman niya. Sabi nung offended, di ba na, umalis na siya. He was charged with impossible crime because there is a legal, physical impossibility of committing robbery, a crime against property. The Supreme Court said there is no impossible crime there because the act falls under other provisions of the revised penal code. It would have been at least grave theft. Pag di mo binigyan rin mo, patay ka. Provided for under Article 282. 280 is trespass. Under Article 282. So, walang grave theft. But, in the case of Intot versus Court of Appeals, Intot with his Barkada wanted to kill the intended victim. And he went to the house of the victim. They went to the house of the victim. After that, malay. Dito sa room na ito. Diyan tumutulog yung kalaban natin. They fired the fan, the walls, breaking the walls. It so happened that the intended victim was not there. Nobody was up, nobody was killed. They were charged with attempted murder, found guilty by the CFI, appealed by the Court of Appeals. On appeal, alam niyo sabi ng Supreme Court, the crime committed is impossible crime to commit murder. Because they were performing an act which would have been offense against person, murder, were it not for the inherent impossibility of its accomplishment. They said inherent impossibility is physical impossibility. Eh, wala din yung napatay. But I thought, in a previous decision, sabi ng Supreme Court, if the act falls under other provisions of the revised penal code, wala na impossible crime. This in Todd versus Court of Appeals, when they fired upon the walls, breaking the walls, at least that is malicious mischief under Article 327. And it should not have been impossible crime. But that was the Supreme Court. Pag sinabi ng Supreme Court yun, we have to follow. The Supreme Court cannot do any law. There is no more appeal. Kaya itong midnight appointment, takot dito si Noynoy Aquino. No more appeal. The Supreme Court said, hindi midnight appointment, hindi covered, the judiciary, hindi covered. Supreme Court, 7 books, and 9. So, when the NTC commits an error, the RTC would correct the error. When the RTC committed a mistake, the Court of Appeals would rectify it. When the Court of Appeals committed the error, the Supreme Court will correct. When the Supreme Court commits the error, it becomes the law of the land. And you and I have to follow. Wala na kasing appeal. That's why many law students do not like to be compared to the Supreme Court. There is no more appeal. 3 stages. Dito sa stages. Maganda to. 3 stages. Consummated, frustrated, and attempted. Consummated when all the elements necessary for its execution, accomplishment are present. Frustrated when the offender performs all the acts of execution, which should produce the penalty consequence, but which nevertheless do not produce it by reason of causes independent of the will of the perpetrator. And there is an attempt when the offender performs all the acts of execution, when the offender commences the commission of the crime by overlap and does not perform all the acts of execution which should produce the penalty by reason of some cause or accident other than his own, other than his own will. So, all these consummate, attempted, frustrated, and consummated are punishable by law. If asked to give an example, sometimes you can say, example, A shot with intent to kill. He shot Mr. B by 9 mm. He missed him, or hit him only by a superficial part of the body, attempted murder wrong. A shot B, hitting him in his vital portion of the body, but because of timely medical intervention, the victim was treated in UST hospital. He did not die, frustrated murder or homicide. A shot B, hitting him by the head, he died, consummated murder. But there are many, sometimes you have to consider many things. In arson, if you burn a building, a portion of the building gets burned, even how it's like, konting-konti lang, that is consummated arson. Before you are holding a torch, intending to build a house, to burn a house, before you could burn it, hindi pa nasasalayan ng apoy, policemen came, arrested you, that is attempted arson. Oh, how can there be a case of frustrated arson? It will be illustrate an example of frustrated arson. Mr. A put sacks soaked in gasoline around a house, intending to burn the house. And then he lighted those sacks soaked in gasoline. Before any portion of the house gets burned, he was arrested. That is a case of frustration.